Good morning, ma'am. And I see Mr. McKinley. Good morning, sir.
Good
Very
morning,
good.
Your Honor.
Good morning. All right, we're ready to proceed. And just a reminder, Mr. McKinley, you have 20 minutes and you can reserve up to 5 minutes for rebuttal. What is your pleasure, sir?
Thank you, Your Honor. I would request that I reserve 3 minutes for the rebuttal.
3 minutes? Very good, sir. And whenever you're ready, the court is ready for you, sir.
Okay. May it please the court. My name is Richard McKinley. I'm here on behalf of Kelly Renee Hesters, who's the appellant in this case. This is an appeal from a final order establishing parental responsibility and time sharing. We've raised 3 issues in the brief. One is that the findings in the final judgment are not supported by substantial competent record evidence. 2, that the trial court failed to independently determine the issues that were before it based on the record evidence. And that there's a virtual verbatim adoption of the closing argument that was submitted by the respondent. And the third one is that the conditions on the mother's time sharing, despite absence of substantial competent evidence to support them, are not appropriate. I'd like to start with this observation, and that is that this case proceeded to trial as an initial parental responsibility determination under 6113. There had been 10 years before a dependency action not pursuant to the 6113 criteria. Those issues were not determined. And this case proceeded as an initial best interest determination with respect to parental responsibility and time sharing. If we look to the record, there were 4 witnesses who testified, the 2 parties, a lady by the name of Cindy Kennard and another lady by the name of Miss Golden. There were no exhibits which were offered in evidence. So this is the record upon which the trial court in this case was asked to determine the issues that were framed.
And Mr. McKinley,
if we look,
Mr. McKinley, can I just interrupt you? These
Yes,
type of cases are always very, sad to read and sad to even witness. And I just want to be able to start by saying this. But as you know, right now, we sit here we're not the trier of fact. We sit here as an appellate court. And right now, what our burden is basically to review whether or not the trial court's decision as to this, time sharing, whether it was really, he abused, there was an abuse of discretion. So that's a pretty high mark. And in looking at the judgment that was entered by the trial court, because I know you're about to go through and say so-and-so testified, there's no exhibits. But if you look at the judgment does contain detailed findings evaluating, at least in the judge's mind, what would be the best interest of the children. And you went through every single factor that's set forth under 621. So the court is a fact finder. His judgment designates and delineates all the findings that came to the conclusion why the judgment did enter the way it is. The court, as you know, is not required to believe, your client's version of events. So how can we, sitting in the appellate court with an abuse of discretion, based on this record, overturn the judge's decision?
Thank you, Your Honor. Your Honor has correctly identified the abuse of discretion standard and correctly identified that this court did, in fact, address 6113 criteria in the final judgment. The argument that is advanced here is that substantial of the findings that are made are not supported by the record evidence that was presented to the court. And I have pointed out some examples in my brief, and would go through that. I'm not here to re-argue the evidence, but there are findings, for example, that we believe are not supported by any record evidence, which would indicate that there are deficiencies in the final judgment, that it is not supported by competent substantial evidence. In fact, no evidence as to certain of those findings, and that those findings, which are not supported by record evidence, drive the conclusion that the court made in a way which is inconsistent with the court's obligation. As some examples.
Did your client agree with the court that she was a virtual stranger?
Honor, I'm having a little difficulty here.
Did your client agree with the court that she was a virtual stranger to the children?
I didn't hear that.
The children had never met. The children had never met her new family.
Yes, sir.
She admitted in the record when the judge inquired that she was a virtual stranger to her children because she waited 8 years to do this. These are tough cases, but objectively, she waited 8 years to do anything in this case and conceded, the children don't know me. They do not know me, and they certainly don't know my new family that I want them to live with. Why isn't that sufficient evidence to support this?
Query whether that standing alone would have supported the judge's conclusion. Yes, she did acknowledge that she was a virtual stranger to the children. However, the judge's order placed significant weight on findings of repeated domestic violence and of illicit drug use, and there was no evidence of repeated domestic violence in the presence of the children. There was evidence of one particular incident which had occurred when the children were less than 2, and there's no evidence that they saw that. Domestic violence which were talked about, there was no link showing that that was in the presence of the children, and all of it would have been 10 years or older. The illicit drug use reference, there was not evidence of that as a driver in the things that were here. And then the judge relied on findings that spoke to those particular issues.
Well, I'm talking about what was actually adduced at the hearing. The past domestic violence was when she rammed the father's truck with her car while the children were in the car. That's a consideration, but it doesn't appear to me that that is the linchpin of this decision. The decision is based on the children have absolutely no relationship with the father, and they all live in, I think it's Arcadia, I'm not sure. She lives in Okeechobee. Arcadia. And they do not know her new family at all, and they would be sleeping in the house with a new family and also an extended family member that they do not know, which is more than 50 miles away. They're used to living in Arcadia and being fathered by the child. I mean, this isn't a case where the mom is completely prohibited from any visitation, right?
As to your question, it's not a case that she's prohibited from any visitation. You're correct with that. There was no record evidence as to the distance between Okeechobee and Arcadia. How that found its way into the judgment, I can't speak to that, but there was not record evidence of that. The public
Well, how far is it? I
policy,
mean, we could take judicial notice of that because that distance is not going to change.
we certainly could take judicial notice of it were it properly presented before us, but it's not been done, and there's not been an order entered where there was an opportunity to speak to or address that, Your Honor. The other factor that was developed in the brief that we developed was the court's conclusion that my client was under directions of a psychiatrist to treat, and that was not the evidence. There wasn't record evidence of that. The evidence was that she was in counseling, that she had decided to basically, she didn't like the medications that had been prescribed to her, but there was no evidence as to the circumstances of the prescription, whether they were prescribed as needed or whether she was supposed to take them. But the court concluded in its findings that she was non-compliant with a psychiatrist's directive, a finding that's not supported by the record.
Well, but there was an opportunity with counsel below when the court inquired about that and specifically asked, were those prescribed medications from a psychiatrist? And she said, yes. He said, did you stop taking them? She said, yes. She did it on her own. She did it on her own. And there was no follow-up by anybody below representing her. I don't know if you were there or not, to clarify that. To clarify that. So she went off SSRI, psychotropic drugs, whatever, because psychiatrists don't prescribe over the counter. And these are drugs that deal with your neurological and your psychological issues. And she went off of them on her own.
Your Honor, your observations, your questions, I think are well taken. However, they require some of the questions that you've asked assume certain things about the medications that she was on. The testimony was that she was having some anxiety issues. This is 10 years post the incident in 2002. It wasn't that she was experiencing bipolar manic depression or schizophrenia or anything like that. And in fact, there was no record evidence developing the significance of any of that. So we don't have evidence of the drugs, but we had the judge going from, I decided that I was not going to take the prescription when there's no evidence as to what the prescription was, what the regimen was, whether there was in fact a regimen, and the judge went ahead and made findings that she was non-compliant, which I believe we submit were significant findings that the court relied on in making its ultimate conclusion. For a court to impose restrictions on a parent's access to its child or on the time sharing, there has to be a well-supported, there has to be competent, substantial evidence which supports the restrictions. In this particular case, the three restrictions that we have are time sharing must be supervised by a specific person. Time sharing must occur in a public place. Although there wasn't an articulated basis that's current for doing that, and that no other individual shall be present during the petitioner mother's time sharing. So in order to restrict time sharing, then there has to be substantial competent evidence to justify that. In Lovell v. Lovell, 14 Southern 3rd, 1111.
Mr. McKinley.
Yes,
if I
ma'am.
may, and I appreciate that, but I think we have to look at the facts, and in looking at the order that the court entered, I mean, based on the facts, based on the evidence presented, I think you'd agree, the court indicated there was a complete lack of communication between the parties since 2011. And then also, there's also evidence presented that, again, since the father has done everything for their twins, the mother hasn't really had any in contact person with the twins since they were 10 months old. And didn't she, in fact, within the case below, testify that she was willing to submit to supervised visit if they're ordered by the court? And I think she acknowledged the fact that the children need to be able to have time to get to know who she is, because again, in her words, she's been a total complete stranger. So with that overlay, and these are just some facts, they're not everything. I'm just pulling some of those things. With the overlay, Mr. McKinley, that I mentioned earlier about the abuse of discretion, how can we
Yes, Your Honor.
indicate that no reasonable judge in the entire state of Florida would have done the way this judge has done? That's the concern, and I think that's the focus that we need to be looking at.
The mother testified, yes, that she would be willing to submit to the supervision. She also testified that in her view, supervision was not necessary. So there was kind of an acquiescence at some level, but there was a statement that she did not feel that it was necessary. And I submit that the record, irrespective of whether she said yes or no, the court's job is to determine, based on the record evidence before it, whether to restrain this parent and these children in this way from a relationship with each other, irrespective of what she might have done 10 years ago, which was not, in my view, and to Judge Sleet's observation, I was not the counsel below and certainly might have tried it a little differently, but it was not developed at a level where Judge Hall, from either side, in my opinion, had it fully developed. But
And if I may, Mr. McKinley, I know I asked you that question. You're about to get into your 3-minute rebuttal. Do you wish to stop right now and hear from the other side, or do you wish to go forward?
I would reserve for the 3 minutes. I appreciate the court's time, and we'll reserve the 3 minutes. Thank you.
Very good. Thank you, Mr. McKinley. All right.
Thank you.
Is it, and I don't want to butcher your name. Is it Ms.
Hanaoka.
One more time?
Hanaoka.
Hanaoka. Thank you, Ms. Hanaoka. Whenever you're ready, the court is ready.
May it please the court. My name is Louise Hanaoka, and I represent the appellee, Claddy Savage. In this particular case, we are requesting that the court affirm the final judgment and parenting plan of the trial court. The court touched on to several of the issues, and these time-sharing cases are extremely difficult. This started out as a paternity issue. The parties were never married. They did have twin boys. And the initial case, as referenced by the amended petition filed by the mother, indicated that indeed this started with a closed DCF case wherein the father, Mr. Savage, was awarded permanent guardianship of the twin boys with supervised visitation to the mother. So we started with a supervised visitation schedule in this case. Mother came in 2019 and filed her petition and later an amended petition seeking a parenting plan and parental responsibility. In this case, the court found, as the court's aware, that the shared parental responsibility, i.e. communication between parties, is necessary for the best interests of the children. However, one of the big hurdles in this case, they are difficult cases, is a substantial period of time. between 2011 and 2019, and then 2021 at the trial stage, wherein these children had not had contact with their mother. Part of the issue that surrounded and was admitted by the mother in this case, it was unrebutted, in fact, when Mr. Savage testified about the incident that led to the initial DCF case. Miss Hesters indicated that she completed her case plan in the DCF case in 2011. However, there was no documentation submitted to either that court or the trial court. She made no efforts in that period of time since the DCF case closed up until 2019 to apply for the court for time shared and parental responsibility, although she continued to place the blame upon the father. In the meantime, Mr. Savage did continue to raise the children. There was testimony in this particular case by Miss Hesters that she left the state of Florida sometime in 2014, I believe it was, went to various states, and she did that because, quote, she needed to get her life together. She left the children with Mr. Savage, and she even admitted it several times in the record, particularly at page 219 in the record. For a long time after this had happened, I spiraled down the rabbit hole really bad, and my life fell apart. I know that I was lost. I know that I was young, irresponsible, disrespectful, and making a lot of bad choices. That was Miss Hester's testimony. So what we were left here with was an initial supervised time sharing scheduled back in 2011 and a 2019 amended petition filed and trial testimony and evidence in 2021. My client, Mr. Savage's main concern was the period of time where the children had not seen or heard from their mother. She admitted she is a virtual stranger. I believe she said, I don't think if I walked by them in Walmart, they would know who I am. At the time of trial, the boys were 12. And so what was proposed to the court and what the court accepted on part of Mr. Savage was to deal with his concern about a period of reunification. Even Ms. Hesters indicated she felt that it was in the best interest of the children that there be a phased in or a transition period where she could reintroduce herself to the children and go on from there. And what the court did was, after addressing all the concerns that were brought out in the testimony, enter into a final judgment that went through all the specific factors in 6113. Mr. Savage did testify to more than one incident of domestic violence, just to address what was previous related to this court. And so when determining—
And Ms. Hanoka, I was also looking at this, and the court started with an initial reintroductory period, but didn't the court also give the opportunity to revisit the unsupervised time sharing at a later date?
Absolutely, Your Honor. And the purpose of that was to have the court involved to see at that point what the best interests of the children were and whether at that point to introduce them into overnight time sharing. Again, since the time sharing in a new household with a new husband, a new stepfather, and I believe it's a great aunt in the household, was going to, before the court was comfortable with that, there was going to be another court intervention to see if that point, at that time, the best interests were served.
And that also ties in actually her own testimony when you said earlier that she's a stranger to the children. I just pulled this quote that she would like to take a slow step process into, gaining their trust, their respect, and our relationship building. And that's commendable. Her realizing that that's need to be done. And it seems to me, based on the record, The court was exactly doing that. Let's just start slow. Let's just see
That's
how things go. And never said, this is it, this is final. It gave that opportunity to revisit this. So with all of that, and with the high burden of an abuse of discretion, this is what we're grappling with right now.
Absolutely. And the trial courts are dealing with very difficult issues in these parenting cases. However, under 6113, as the court's aware, there's no presumption for or against specific schedule of time sharing under 6113. And the court has an obligation and a duty to ensure the best interests of the children and the safety and welfare of the children. I believe that's what the underlying court did in this case. So we would request that the court affirm the final judgment and parenting plan of the trial court.
Very good. Thank you, Ms. Hanaoka. Mr. McKinley, you do have your 3 minutes for rebuttal, sir.
Thank you. May it please the court. I would simply point out that there's not been a showing on this record that time sharing without supervision would be detrimental to these children. That has not been shown. I respect Judge Schlicht's observation about the stranger and the emphasis in the record on the stranger. Children run into, they have new teachers every year. They have new situations. These are 11-year-olds. This is their mother. And in response to counsel's observation as to, and speaking to that particular issue, if you read this order, this final judgment, it is inescapable, the conclusion that the court significantly placed very significant weight on two things, the domestic violence allegation and two, the drug allegation. Those two conclusions are inescapable. The domestic violence, there was one incident in the presence of the children, no other evidence as to domestic violence in the presence of the children. And it's also remote. It's over 10 years old, that it should be given very, very little weight. As to the psychiatric treatment and the drug use, I'll stand on the brief that there's no, the father could have presented evidence as to those issues, and he did not flesh those out sufficiently to support the findings that the court made. Thank you. We submit that the judgment should be reversed.
Thank you, Mr. McKinley, and thank you, Ms. Hanaoka. Really well argued on both sides. Thank you both.
Thank you, Ms. Hanoka. Thank you, Your Honor.
All right.